Thank you very much. It's a pleasure and an honor to be here with many old friends in ASEAN and with new acquaintances. And I thank the HRC for inviting me to speak at this event. Actually, the first two speakers, Professor Tuti and Ambassador Ong, have really already said everything that I should have said in speaking about the rule of law and the rules-based ASEAN. What I will try to do is to focus in a bit more detail on some of the very important issues that they have raised in giving us this both broad and fairly comprehensive overview of some of the challenges that ASEAN is currently facing in making the rule of law a reality. So, as we've already heard, we're now 10 years past the ASEAN Charter coming into force. And so it is an appropriate time to consider where we are in the trajectory of realizing and implementing the principles that the Charter articulated and the ambitions that that document contains. Let's go back for a moment to 2009, I'm going to refer to one of the largest studies that has ever been undertaken of ASEAN law, which was launched in 2009 at the National University of Singapore Center for International Law, a project called Integration Through Law, the ASEAN Way in a Comparative Context, the Role of Law and the Rule of Law in ASEAN Legal Integration. That was the title of this project, which resulted in the publication of many monographs and so forth. So, at the launch of the project, the Center for International Law produced a publication in 2009, which set out the goal of that project, and that gives us a view of the optimism with which the Charter was greeted at the time. We read that one of the key objectives of the project was, quote, to make a decisive and long-lasting contribution to the understanding of ASEAN and its strong commitment to the rule of law, both within the ASEAN region and in the world, especially in light of the ASEAN Charter undertaking. Now, I think that quotation, emphasizing the strength of ASEAN's commitment to the rule of law in the ASEAN region and in the world beyond, however ambitious that might be, reflects the optimism that was felt in many quarters with the adoption of the Charter. After all, through the adoption of the Charter, ASEAN assumed for the first time a legal identity. It moved beyond the association that had characterized ASEAN for its first 4 decades. So there's no question that the Charter was a great achievement and a landmark in the development of an ASEAN community. However, was that optimism that was expressed in various quarters, like the one that I just referred to, was that justified in light of what has transpired in ASEAN in the past 10 years? Has ASEAN fulfilled the promise of the Charter and realized what that study from the NUS called its strong commitment to the rule of law within ASEAN and in the world? So what I would like to do this morning is to reflect a bit on what it means for ASEAN to realize the rule of law, at least in the region, if not in the world. Although we do have to consider another dimension of rule of law in ASEAN, and that is the international framework that most ASEAN states, and in many cases, all ASEAN member states have obliged themselves to in terms of both international human rights obligations and various other international treaties, including on the law of the sea. So I think it's a legitimate question to ask at this point, 10 years on, because although there is a great deal of discourse today about ASEAN as a rules-based community, it seems to me that the more ASEAN invokes the mantra of a rules-based community, the less official discourse we hear about the implementation of the rule of law. Now that may be because we think, oh, well, rule of law, rules-based community, those are just the same things. So whenever ASEAN talks about a rules-based community, what they mean is the rule of law. I think that's not so clear. And that's one of the topics that I would like to raise today. That is, we have a fundamental question of whether or not a rules-based community among a community of states is the same thing as a community based upon the rule of law. And I think in order to answer that question, and it's not an easy question to answer, I don't pretend to have an answer, we have to consider what is the nature of the rule of law? What would be required to actually say that ASEAN has embodied the rule of law as a region and as a group of 10 member states? That is the promise of the Charter, and so it is a legitimate and pressing question to ask. So I'm going to ask us to consider 4 questions. One, what is meant actually by the term rules-based community in ASEAN? What is that? I mean, there have been academic papers published on this. Some have been positive, some have been critical, and so forth. But I don't think we will find an ASEAN document that really presents a coherent, well-argued interpretation of exactly what the requirements are to say that ASEAN is actually a rules-based community, rather than ASEAN has committed itself to becoming a rules-based community. So that leads us to the second question. What are the necessary conditions to say that ASEAN is a rules-based community? That is, what does ASEAN have to achieve in order to say, okay, you've been talking about being a rules-based community, now you are one? That raises the question that I've mentioned before. Is a rules-based community the same as a community governed by the rule of law? And that is a question that I think has not been answered within ASEAN. And I would also point out that one of the ASEAN bodies that one would think would be most likely to take up this question would be the ASEAN Intergovernmental Human Rights Commission, which in its mandate refers to the rule of law. But let's just say that the rule of law has not been high, if at all, in the work plan of the ASEAN Intergovernmental Human Rights Commission. So where in ASEAN is there a body that is actually considering to what extent ASEAN has implemented the Charter principle of the rule of law? Finally, the last question is one that I've already raised. Is ASEAN in fact strongly committed to the rule of law, as opposed to saying that it is a rules-based community, and a rules-based community in some way involves the rule of law? What would be needed to manifest such a commitment? In other words, what do we look at in action beyond words to say, okay, yes, ASEAN really has made a commitment to the rule of law, and rather than just saying, yeah, there's some pieces of paper that refer to the rule of law. But what would be required to actually say or to evaluate the state of the rule of law in ASEAN? if we look, for example, at ASEAN's apparent inability to act decisively to create and implement at the national level a body of law that would enable it to deal effectively with some of its most pressing issues, we might not be so optimistic about the answer to my question. We've already heard ways in which ASEAN and Ambassador Ong very eloquently spelled out the way in which ASEAN is quite a way from implementing international legislation, the obligations that it's undertaken in ASEAN agreements. The ACTIP is a good example. But is it a surprise? After all, every ASEAN member state had already ratified the Palermo Protocol, and the ACTIP, the ASEAN Convention on Trafficking in Persons, essentially just takes most of the Palermo Protocol, but with some important differences, and then makes a regional agreement. The Palermo Protocol, like the ASEAN Convention on Trafficking in Persons, requires all member states which ratify the convention to implement into their national legislation the obligatory provisions of the convention. But as we've already heard, not many have done so. What about ASEAN's apparent inability to create a effectively binding legal framework to deal with the environmental crises, the trans-border environmental crises that are affecting this region, and in many ways growing worse every day? What about the decades that it has taken to try to adopt a code of conduct on the South China Sea? One of the most pressing security issues, environmental issues, political issues, and so forth for ASEAN, as it is in this situation that we've heard described, where ASEAN is between its neighbors like China, the United States, Japan, Australia, and others with competing interests. What does that tell us about to what extent there is a gap between promise and reality? So let's begin by just looking at what the Charter actually says. Now, the Charter actually does not articulate a principle of a rules-based community. The preamble to the Charter provides that in adopting the Charter, the member states are, quote, adhering to the principles of democracy, the rule of law, and good governance. These principles are then articulated in Articles 1 and Article 2 of the Charter. So that raises a question. Well, the rule of law, rules-based community, same thing? Rules are different than law. Why use the term rules-based when the Charter has guaranteed the peoples of ASEAN the rule of law? One reason I would suggest is that rules-based community is a vaguer and weaker term. Rules rather than laws may be used because of the baggage that is inevitably associated with the term law and the rule of law. What's that baggage? It's the expectation of an institutional infrastructure for the creation, interpretation, and enforcement of law. That is what we would expect in a legal system. And normally we associate the rule of law with a legal system. Any group, any club, any association, any company can make rules. Rules do not necessarily require a formal legislative process. Laws presumably do. Rules do not require a mechanism for enforcement. But many, if not most, legal philosophers would argue that the very nature of what law is requires a formal process by which laws may be interpreted and enforced. And after all, how can laws be effectively enforced without a mechanism to interpret them, to resolve contradictions within the law, and in a regional association to resolve conflicts between the laws of different member states, and the lack of adherence of national law to regional commitment. So the rule of law, I would argue, certainly traditionally requires an institutional structure. Speaking of ASEAN as a rules-based community seems to sort of finesse or eliminate the need for discussing many issues that many ASEAN member states do not want on the table. Look at where suggestions about the need for an ASEAN Human Rights Court have gone. That's a subject no one wants to talk about. What we sometimes refer to as the EU allergy, the European Union allergy, that the moment you start talking in an ASEAN meeting about the way they do it in the European Union, of course everybody just shuts off, because that is not the vision of ASEAN. A European Court of Human Rights, a European Commission, a European Parliament, and so on and so forth. But those are institutions that at least have brought the European Union closer to being able to say that the rule of law obtained in the European Union, however imperfectly it might operate. So, leaving aside some of those questions, if we were to say that ASEAN has achieved being a rules-based community, what would we need to see in order to make that statement? For one thing, it would seem to require a clear and coherent body of rules, not a random collection of agreements that happen to reflect the national interest of the member states in advancing the process of economic integration in order to promote foreign investment and development. So, what is more, and this is certainly the point that Ambassador Ong made very forcefully, to call a community rules-based rather than a community that has some rules, one would seem to require that the rules are actually implemented and compliance and non-compliance are institutionally monitored, and that there is some mechanism for ensuring compliance. That's what it means for a community to be based upon rules rather than to have some rules. The ASEAN Eminent Persons Group was convened at the time of the creation or the drafting of the Charter. And it already, before the adoption of the Charter, foresaw this problem. The Eminent Persons Group stated, quote, this is more than 10 years ago, ASEAN must establish a culture of honoring and implementing its decisions and agreements and carrying them out on time. Delays in non-compliance will be counterproductive, will undermine ASEAN's credibility, and disrupt ASEAN's efforts in building the ASEAN community. ASEAN's problem is not one of lack of vision, ideas, and action plans. The real problem, the Eminent Persons Group continued, the real problem is one of ensuring compliance and effective implementation of decisions, end quotation. So one thing we might ask in measuring 10 years on, has ASEAN achieved a rules-based community, is to what extent was the this statement by the Eminent Persons Group of ASEAN prophetic? To what extent has ASEAN met that challenge that the Eminent Persons Group some 11 years ago clearly saw? One of the obstacles, and this is well known, one of the obstacles to ensuring compliance and effective implementation, which the Eminent Persons Group said would be required for rules-based ASEAN, is that ASEAN, since its very creation, has been an association that operated in a very different way, in an informal way, the ASEAN way, as it's usually called. In another article published at the time of the adoption of the Charter, one well-known commentator noted, quote, "The ASEAN way is often dramatically opposite to the rule of law and institutions. ASEAN stakeholders might not yet have realized that both modalities do not coexist easily, such that an installation of rules-based mechanisms in a system operating on the ASEAN way merely translates to cosmetic rather than substantive outcomes." End quotation. The informal way in which ASEAN decision-making has operated for decades, and the equally informal way in which decisions are enforced and implemented or not enforced and not implemented, seems at odds with the rigidity that a genuine rules-based order seems to imply or require, let alone the structure of compliance that one would expect if we were to say that ASEAN now operates under the rule of law. It would seem, and I've already mentioned this, that a genuine rules-based community would require a formal mechanism, if not for the promulgation and interpretation of rules, then at least for tracking their implementation in an authoritative way, measuring compliance, and providing a mechanism for ensuring compliance and accountability for non-compliance. Do we have such a mechanism in ASEAN? So, to call a community or association rules-based means simply that the rules must be respected as the norm. Obviously, in any association, rules are not always respected. But if the norm is that they are not respected, that they are not implemented, then what do we mean by saying we have a rules-based, that we have a rules-based community? In the case of ASEAN, it seems that this would require both an authoritative mechanism to produce and register the body of rules that are binding, and to measure their implementation in international legislation by member states. But since ASEAN is composed of sovereign states who very vigorously defend their sovereignty as part of the ASEAN way, and these member states have not granted rulemaking authority to any regional body, it also requires that the ASEAN member states implement the rules through incorporating them into their national legislation, as we've already heard. But this process needs to be monitored and tracked. Further, if these domestic laws are enacted, as Ambassador Ong has already indicated, they need to be implemented. What is required for implementing even one ASEAN agreement, like the ACTA, the Convention on Trafficking in Persons? It requires training of thousands of officials at the local level, at the regional level, and at the national level, of judges, of prosecutors, of police, of immigration officials. In most ASEAN member states, there are at least 15 different government agencies that are members of what is usually called an interagency task force on trafficking in persons. Unless the ACTA has been implemented in a national law, and unless all of those agencies are on the same page in terms of understanding what the requirements of that law are, which would be new to them in many cases, where national trafficking legislation differs dramatically from the requirements of the ACTA, then how is that agreement going to be implemented? So there is clearly a huge need in ASEAN for not only implementing agreements in the national law, but in making them operative in the complexity of ministerial and judicial structures that are required to implement them. And it's wonderful that we have here today three representatives of the Council of ASEAN Chief Justices, because that is certainly a step in that direction that ASEAN judiciaries are taking in terms of beginning to think about the role of judiciaries in cross-ASEAN judicial training on transborder legal. So I've just outlined a number of steps which I would think ASEAN would have to take in order to say that we have now achieved a rules-based community, or at least that we have moved closer to it. If all of those steps were taken, ASEAN would also be much closer to transforming a rules-based community into the rule of law. But those are the kinds of steps that would be needed. What else would be required to instantiate the Charter's principles? That is, in order to say that ASEAN actually has embodied the rule of law principles that it articulated 10 years ago in the Charter. At the institutional level, there would have to be institutional changes that many ASEAN member states seem unlikely to accept. So I think we have to pose two questions here. The first is, can ASEAN actually implement the rule of law without a legislative function that can create a systematic and coherent body of rules, of laws? Can it do so without a mechanism to interpret those rules in an authoritative manner and develop a body of ASEAN jurisprudence that can be applied at the national level? And can it do so without some kind of enforcement function to ensure compliance and potential accountability for violations of ASEAN law by member states? The second question, I think, is even more challenging than the first. And it's a difficult one to answer, I think, at both a theoretical and at the practical level. Can ASEAN be said to have the rule of law as a community of member states when many of the member states themselves do not have the rule of law? That is, have governments that do not function under the rule of law. In other words, is the rule of law at the national level a requirement for achieving the rule of law at the regional level? I don't think I need to go into detail in saying that in terms of achieving the rule of law at the national level, a number of ASEAN member states in recent years seem to have been moving in the opposite direction rather than in the right direction. These are big questions, and they can't be answered quickly or easily, and I don't pretend to have the answers to them, but I think they're important questions for us to discuss. These are points for discussion that go to the unique nature of ASEAN as a regional association. That is, an association that for 4 decades functioned in a certain way and then decided to assume a legal identity. And as part of that legal identity say, well, we're now a rules-based community. We now accept the principle of the rule of law and of good governance. That's a gigantic challenge to basically change in midstream. Years and years of practice, years of institutional and political culture, years of informal ways of doing business. I don't pretend that that is an easy challenge, but if we want ASEAN to be a rules-based community and to instantiate the rule of law, we have to recognize the nature of that challenge that it faces. One thing we might look at briefly before I close in a few minutes is the document that one might expect to be the ASEAN agreement, which would provide a foundation for the achievement of the rule of law. What is that? Well, one would think it would be the ASEAN Human Rights Declaration. After all, where better to look for ASEAN's commitment to the rule of law than in its Human Rights Declaration? Where better to look for implementation of the principles of the Declaration than to the overarching ASEAN human rights body? the ICHR, the ASEAN Intergovernmental Human Rights Commission? Well, the starting point is that the ASEAN Human Rights Declaration is a declaration. It's not a convention. And we might ask why it's not. And there have certainly been calls repeatedly, both before the adoption of the declaration and since, for an ASEAN Human Rights Convention. That is a legally binding human rights instrument for ASEAN. But the call for that convention does not seem to be getting very far. So it's hardly a coincidence that we have a declaration rather than a convention. So let's look for a moment at the state of ASEAN commitments to the rule of law in ASEAN documents. The leaders of ASEAN have promised their citizens a rules-based community that is based upon the rule of law, good governance, democracy, and the promotion and protection of human rights. That is in the ASEAN Charter. Such a rules-based community, ASEAN leaders have repeatedly articulated, is necessary to ensure, quote, peace, prosperity, and sustainable development for the peoples of ASEAN, unquote. ASEAN is to be a people-centered, people-oriented community. I've never really quite understood the difference between people-centered and people-oriented, but I'm sure there is one. That community, according to the ASEAN blueprints, will be achieved by 2025. Well, that's only 6 years away, actually only about 5 years away. So how are those commitments articulated? Well, we start with the Charter again, and I've already quoted the commitment to the rule of law in the Charter. It could not be clearer. It's in the preamble, and it's in two of the principles, in Article 1 and Article 2. On the other hand, the Charter also incorporates the ASEAN way. So other Charter principles give member states considerable leeway in how to interpret and implement the rule of law within their national borders. Article 2E, for example, sets out what has been one of ASEAN's most fundamental principles since its foundation in 1967. Non-interference in the internal affairs of ASEAN member states, widely interpreted as not criticizing or publicly calling out any member state, which appears to be drastically not in compliance with the principles with the principles of the Charter. Article 2L provides for respect for the different cultures, languages, and religions of the peoples of ASEAN while emphasizing their common values in the spirit of unity and diversity. You add that to Article 20.1, which is ASEAN decision-making by consensus, and you have a mechanism which is rather imperfect in terms of its ability to enforce some of the principles in the Charter. The ASEAN Human Rights Declaration goes even farther in this direction of internal contradiction. On the one hand, the Declaration reaffirms the commitment of the ASEAN Charter to the principles, reaffirms the commitment of ASEAN to the Charter principles. And that commitment was reiterated in what's called the Phnom Penh Statement of the ASEAN Heads of State at the ASEAN Summit in 2013 when the ASEAN Human Rights Declaration was adopted. That states reaffirming ASEAN's commitment to the purposes and principles as enshrined in the ASEAN Charter, including the principles of democracy, the rule of law, and good governance. That's in the preamble. What's interesting is that is the only time that the term rule of law appears in the ASEAN Human Rights Declaration. In the substantive part of the declaration, that term is never used. There are, of course, some principles in the declaration that reflect a concern for what we would consider to be constituent elements of the rule of law, like fair trial rights and so on and so forth. But there is no formal commitment to the rule of law in ASEAN Human Rights Declaration. Beyond that, the problem with the Declaration is that, like the Charter, what one principle in the Declaration appears to guarantee, another principle appears to qualify, relativize, or undermine. So, for example, the Declaration provides that all human rights are universal, indivisible, interdependent, and interrelated. That's a quotation. On the other hand, the very same paragraph also provides that the realization of those rights must be, quote, considered in the regional and national context, bearing in mind different political, economic, legal, social, cultural, historical, and religious backgrounds. I mean, those two parts of that paragraph are completely incompatible, and they're a reflection of, and Ambassador Ong has pointed us to that already, of the inevitable compromises that arise at the negotiating table and make it possible to get a declaration. That's why when the declaration was promulgated, there was a big discussion about, well, are we better off or worse off? Is the glass half full or the glass half empty? What the Declaration apparently means, in plain language, is that although it recognizes the existence of rights in the abstract, the implementation of them is purely at the discretion of the member states when they believe that it suits their interest to implement them and not otherwise. So what about, then, the ASEAN blueprints? ASEAN blueprints are the vision of ASEAN for the achievement, for the implementation of the goals of the ASEAN Charter, of ASEAN Declaration, of ASEAN agreements, and so forth. So, in 2015, at the end of 2015, with the launch of the ASEAN Economic Community, the blueprints for all three pillars were promulgated together in a document entitled, quote, ASEAN 2025, Forging Ahead Together. That document was endorsed by the ASEAN Summit and the Kuala Lumpur Declaration on ASEAN 2025. I'm not going to go into a detailed analysis of the language, but I think what one would find, if one does engage in a comparative analysis of the preceding blueprint, that is the blueprint that went up to 2015 in comparison with the blueprint that goes up to 2025, is that there has actually been, in the language of the blueprint, a retreat from commitment to the rule of law, rather than an advancement of the rule of law. In the preceding blueprint, there's actually a very strong articulation of the Charter principles as one of the goals to be achieved in the ASEAN blueprint that ends in 2025. What do we have that ends in 2015? Sorry. What do we have in the 2016 to 2025 blueprint? What you will find is that there is actually no paragraph in the substantive part of the blueprint that articulates a commitment to the rule of law. The rule of law is basically relegated to a subject which requires training at the institutional level in ASEAN institutions, rather than an overarching principle. I mean, if this is something you want to discuss later on, I could, of course, provide the actual language. So, what we find then in the blueprint, in the forging ahead together, is that first of all, the rule of law is covered in the political security community blueprint. It is not covered in the other two blueprints, which itself is interesting. And that in the political security blueprint, the only reference to implementation of the rule of law is that ASEAN shall establish programs for mutual support and assistance among ASEAN member states in the development of strategies for strengthening the rule of law, judicial systems, and legal infrastructure. End quote. That's a far way from the principles, the fundamental charter principles of interlinked good governance, human rights, and the rule of law. Rule of law in the Blueprint 2025 becomes a matter of technical cooperation, such as developing case management systems and other elements of legal infrastructure, rather than an overarching guiding principle of ASEAN. What explains what, on my view, and certainly open to disagreement, what explains the apparent retreat from the robust treatment of the rule of law in the preceding blueprint to the current blueprint? I don't have a clear answer to that. It certainly would be something we might discuss. A cynical interpretation might be that given the political developments taking place at the time of the drafting of the blueprint in a number of ASEAN member states, the rule of law was not exactly something that member states wanted to emphasize as an overarching goal of ASEAN in achieving the Community 2025. But I mean, that is purely speculation on my part. What's interesting is that another striking difference between the two blueprints is that while the 2025 blueprint sort of retreats from the rule of law, where it advances is on the issue of corruption. There is a much more robust set of provisions in the 2025 blueprint on combating corruption than there is in the preceding one. And I think it's fair to say that in the preceding 10 years, corruption was still a very sensitive issue that most people did not want to be on the table. However, the new blueprint coincided with the development of the launch of the ASEAN Economic Community. And I think there was a clear realization that in order to achieve the goals of the economic community, combating corruption is essential. The irony is that combating corruption and the rule of law are two sides of the same coin. How do you combat corruption without the rule of law? Well, the fact is you don't. Because how can you possibly enforce anti-corruption legislation in a society which lacks the rule of law? Corruption undermines the rule of law. It's a challenge to the rule of law. And the rule of law must be strengthened in order to combat corruption. And that, I think, will lead us into that observation, I hope will lead us into some of the issues we'll be discussing in the afternoon session. Because as we turn to the importance of the rule of law for the achievement of progress in the ASEAN economic community, it would seem quite clear that advancing the rule of law, advancing the fight against corruption are necessary components of achieving economic development, the economic development that the Charter and the blueprints promise in order to create a peaceful, prosperous, people-centered ASEAN